Greetings. Father Mark signing on, continuing the course on the history of Catholicism in the United States, moving into the decade of the 1870s. 1870 was an election year. Ulysses Simpson Grant became the 18th President of the United States. From March 4th, 1869 to March 4th, 1877. Served 2 terms. He was born on April 27th, 1822, as Hiram Ulysses Grant in Point Pleasant, Ohio. He attended the United States Military Academy at West Point. There, the records added his mother's maiden name, Simpson, as his middle name. He graduated in the year 1843 and was commissioned as a junior lieutenant, a second lieutenant. He embarked on the Mexican Mexican-American War, which we covered already, as a lieutenant. There he earned promotion to captain. After the war, heavy drinking caused him his commission in 1854. Now, I should interject here that historians that write about Grant, and certainly the newspapers that covered him, at least those who were adversarial towards him, always routinely mocked his drinking. But he had an interesting, those who dealt with him on a regular basis. Now, granted, these are people who were loyal to him personally. From their accounts, it seems it was it was situational. That it was there were 2 factors. Like he wasn't drunk all the time. He could go for long periods without drinking, but there were 2 factors that generally intersected to cause his drinking. One was when he was away from his wife, and second was boredom. When he had no job to do. So, but both of them had to be present. Like when he was away from his wife, but he had an absorbing job. Like when he was leading an army, he didn't drink. But it was when he was away from, or if he did not have a job but he was with his wife, he didn't drink. So it's when those 2 things intersected, away from his wife and boredom. But in any case, that's what happened after the war. He was stationed away on a post. He didn't have his wife with him, and there was no fighting to do. He got bored, started drinking, and then lost his commission, which means he was put out of the Army. After that, he moved to St. Louis, Missouri. He failed at multiple endeavors. Nothing really just absorbed him. By 1860, he was working as a clerk in his father's store, leather goods store in Galena, Illinois. In 1861, when the Civil War began, he volunteered. Because he had been to West Point, because he had combat experience, he received a colonel's commission, which culminated in him, and then he entered history there. Then he finally found something that certainly absorbed his attention. He rose to the rank of commander of all the Union armies under President Lincoln, and he is the one who received Lee's surrender on the 9th of April, 1865, which we covered in the previous video. After the war, he was a natural, former general to nominate, like George Washington or Harrison, whom we've already covered. He was nominated as the Republican candidate for president in 1868, and he easily won. He won a re-election for a second term in 1872. So he was president during the occupation of the South, of the former Confederate States, and in the course of which, as we covered in a previous video, the Ku Klux Klan came into being, and Grant did not hesitate to deploy the Army against the Klan and to enforce Reconstruction. as the Northerners called it, or the occupation, as the Southerners called it. Otherwise, Grant's administration was plagued by multiple scandals. That was another, a conventional joke that it was ridiculous how many they were. But it appears that personally he was not corrupt. He died a pauper, but he, maybe because of his military background, he was very trusting of people he knew from the service, and some of those took advantage of his trust, and among those, some of the not all of them, but some of those whom he did trust were men of poor character, and they took advantage of him. Nevertheless, despite the scandals, his personal popularity was undiminished. By the time he considered running for a third term, as at the time the Constitution did not prohibit that. The two-term presidency was just modeled after Washington, the first president who just served 2 terms, even though he certainly could have served another. Grant toyed with the idea of running for a third term, but he did not have sufficient support for it. So he left the White House, returned to civilian life. He was financially destitute, and it was Samuel Clemens, whom is better remembered by his pen name, Mark Twain, found out about this, and he said, you have the way you make money is the way I make money, is you write, but you have an epic story to write from your personal life. So Twain, put him in touch with publishers, and he got an advance to live on, to write his memoirs. And they turned out to be 2 volumes, and they're easily available. You get them on Kindle. And the title is just The Personal Memoirs of U.S. Grant. He wrote it while he was in gruesome pain from throat cancer. He was a chain smoker, loved cigars. And he finished them, shortly before his death. And he died at Mount McGregor, New York, on July 23rd, 1885. The memoirs are worth reading, and as he has a style of writing, which is it's not literary certainly, but it gives some insight into how officers at West Point were trained at the time. It's written, like a report, like a military. This is very detailed, but there's nothing extraneous. So for those who are interested in the details, it's enough where you can follow sequentially everything that happened in the Mexican War, as well as the Civil War, and after. So anyway, if you're interested, they're worth reading. In terms of the church, as we begin the 1870s, we encounter an episode of ecclesiastical discipline. This is the case of Father Eugene O'Callaghan against Bishop Amadeus Rappe, R-A-P-P-E, the Diocese of Cleveland, Ohio. Started in 1869 and into the 1870s. The Universal Church at the time did not have a 1-volume code of canon law, as it does now, seminarians, which you study. The first 1-volume code of canon law was promulgated in 1917. And seminarians, the one you're using now, is the revised, updated in 1983. But prior to that, in this period, in the 1870s, the absence of a 1-volume canon law complicated the problem of ecclesial governance in the United States in the following ways. First, the constitutional secularization of the nation meant that negotiation of a concordat between the Holy See and the United States was not possible. And in fact, full diplomatic relations between the United States and the Holy See did not exist until Ronald Reagan, 1984. So by concordat, a concordat is an agreement on the national level between the Holy See, the papacy, and some government about how the church would interact with the state. But since the United States was officially secular, up to this point, none of the presidents would do that. So, in nations that did have a concordat is in three parts. First is just a treaty of mutual recognition as nations, as nation states, and an exchange of ambassadors. In the case of the Holy See, the ambassador is a nuncio, the apostolic nuncio, and then the other nation would assign a full ambassador to the Holy See. So that's just the first part of a concordat is a treaty, standard diplomatic treaty. The second part of a concordat is stipulates how education and internal governance of the church within that state would be handled. Now that is for the most part, would be in countries where there was some latitude for that. I mean, every country was different where the church was established, and it varied over time periods. There were sometimes in our history when the church had established status in a country, it was a Catholic monarchy, the church had complete control over education. But anyway, a concordat would regulate that. And then there were cases later, especially after the French Revolution, where it was stipulated that other churches would have their own. Like the Catholic Church would not have 100% control over education, but that Lutherans and Methodists or that they would have rights too. But anyway, that was all written out in the second part of a concordat. The third part of a concordat was a financial arrangement and general governance of how would the church and that state interact. So in the absence of all of that, there were problems. So when there were problems, because of the absence of a concordat, the next thing one would do is to consult canon law. Now, canon law, of course, existed, but before the single volume code was promulgated, one had to have access to hundreds of volumes of and go through that pontifical law cases, canonical cases of the Rota and the Signatura, which most didn't have. And even when there were, the United States was something new in history. And so that there really had not been a body of canon law or decisions of ecclesiastical courts related to the specific problems of a country that was, by constitution, atheist. All right, second, the United States was considered missionary territory by the Catholic Church until 1908. Even though we had millions of Catholics, but that's just what happened. So its problems. So in Rome, when there was a problem, the absence of a concordat, absence of clear canonical precedents, then what? Okay, well then the decision would go to whatever part of the Curia, the Roman Curia, would had custody of that or had oversight of that. And so for the missionary, as long as the missionary territory, that would be the Propaganda Fidei, the Congregation of the Propagation of the Faith. For countries that were no longer considered missionary territory, that were just ordinary hierarchy, then any problems would go to the consistorial congregation that would handle affairs. Third, canon law, even without access to the hundreds of books, it was just known. Anyone who had been through seminary training knew that the church law does provide rights of appeal. For example, a pastor has a right, if a bishop wants to transfer him or remove him. A pastor who's duly installed does have a right to appeal that. If for whatever reason. When this happened, since this was in the United States, it quickly became apparent that since the United States was technically missionary territory, technically it had no real pastors in the canonical sense of the term. As a pastor is an ordinary canonical appointment. So if the church in the United States did not have ordinary hierarchical status yet, so there were no canonical pastors, meaning that they were not, that they functionally, of course, they did. But in terms of canon law, there were rectors, not pastors. So a rector does not have canonical rights. So a rector is a direct representative of the bishop. So for an institution that has a rector, canonically, the bishop is actually is the head of that institution. Whereas in canon law, a pastor is installed and that's an office in itself. It's an ordinary office in itself that continues even if the bishop who assigned him is transferred, retires, or dies. The pastor remains. A rector does not. So if a rector is assigned, that's just, he's representing that bishop. So if that bishop retires, is transferred, or died, then that rector no longer has that position unless the next bishop reappoints him. So when a bishop, in this situation, when a bishop once wanted to move a guy who was functionally pastor, and that pastor did not want to move, then he did not have canonical rights of appeal because he was not a pastor. This meant that in the 19th century United States, every attempted assignment of a priest had the potential for dispute that had no ordinary canonical means of resolution because of this bizarre situation where canonically they were all rectors, but functionally they were pastors. And some, especially by the 19th century, and on the parishes on the East Coast might have thousands of parishioners in their churches, and functionally they're pastors, and their people think of them as their pastors. They probably even call them their pastors. But canonically they were not. They were just rectors. Okay. Fourth, in 1855, the First Provincial Council of St. Louis, Missouri, created a process for a rector to appeal. But, canonically a rector, but one who is functionally a pastor, to appeal a transfer or removal. But this process was handled internally within the province. So it invariably favored the bishop. So it was just seen as a drumhead, as just a kangaroo, court. And you have a right of appeal, but it's the bishop's court, So if you're appealing against the bishop's transfer, then his court's going to decide in his favor. Fifth, the Second Plenary Council of Baltimore, 1866, adopted the St. Louis process for the entire nation. Meaning in 1866 there was an appeal process for a rector. Yet, since it was the St. Louis process, the removed priests would invariably lose. And since the absence of canon law in the nation meant the bishop was not required to provide him a living. So then such priests had no choice but to appeal to Rome. So under the code now, is if a priest is removed, when a priest is incarnated in a diocese, then he has certain canonical rights to a living. To survive. It doesn't mean necessarily a paycheck, but he has to be some form of sustenance. So it could be just providing housing, room and board somewhere. It doesn't have to be luxury. But canonically, a priest who is incarnated has that canonical right. But in this case, since there was no canon law, the bishop could remove a rector and was not obliged to do anything for him. So then what? So then then the guy's, well, okay, what does he have to lose? He has to, he has no source of income, no livelihood, no place to live. Literally, he's homeless. So they appeal to Rome, and this happened literally hundreds of times in the 19th century. These appeals to Rome, the plenitude of these cases and the venom of such cases staggered the Vatican. One noteworthy example was this that began the 1870s. Father Eugene O'Callaghan of the Diocese of Cleveland. In 1869, his bishop, Amadeus Rapp, transferred him from Youngstown, Ohio, to Lima, Ohio. Father O'Callaghan objected. And he was simply removed by the bishop. And so he appealed this removal using the St. Louis process, and internally, meaning a U.S. appeal, and he lost. So then he appealed to Rome, arguing that the United States was the only realm in the church where an accused was hanged and then could seek a trial to clear his name. In 1870, he won his appeal. The Holy See sided with him, and the Holy See ordered his bishop to restore him to his original assignment in Youngstown. This decision, like many others, antagonized American bishops. If Rome sided with a priest over them, they felt that they regarded it as undermining their authority, and it contributed to the mistrust between the American hierarchy and the Holy See that had existed since the founding of the proto-diocese in our country, Baltimore, under John Carroll. As we saw, never really trusted the Holy See because he had been a Jesuit, and the Jesuits were suppressed by the Pope for reasons that he regarded as unjust. The Vatican's solution to this problem was to establish an ordinary canonical procedures. But the bishops resisted, arguing that the unprecedented demands upon them in terms of construction of new facilities to accommodate the millions, literally millions of immigrants, and recruitment of clergy would only be impeded by the strictures of canonical norms created that existed in the church, but were created for centuries-old dioceses in Europe. So keep this in mind. 1870s also brings us into a new Bible war. Started in 1869 and then went in up to through 1873. This is the Cincinnati Bible War. The background. In 1869, the School Board of Cincinnati, Ohio. The school board. So this is the secular public school board. Issued a decision that there would be no sectarian religious activities on property of public schools. Sectarian religious activities included hymn singing, Bible reading, and even the Lord's Prayer. Even that could not take place on public school property. The background of this: the school board was attempting to keep the peace. This is only 4 years after the Civil War ended. Ohio was a border state, and it was filled, with contentious, because it was a border state. It had the population was very divided. This significant population on both sides. Those who were sympathetic with the South, and those who were antagonistic to the South, and that didn't go away just because the legal questions about slavery and states' rights were resolved by the Union victory. That didn't mean that people's emotions just were reset. Those who sympathized with Southern Democrats believed that the federal Republicans were trying to eliminate democracy in favor of government dictatorship. Those who sympathized with Federalist Republicans, on the other hand, believed that only a strong central government could ensure the nation's survival. So we're back to this is another version of the states' rights. So, the local control versus the central control. Since Cincinnati, the city of Cincinnati had a large Catholic population, and the Catholics of this period were invariably Democrats, the Protestants were identified with the Federalist Republicans. Religious instruction had previously been allowed in public schools in Ohio, conducted by priests or ministers of the respective churches. Now, generalizations always break down, on the specifics, but so I can't say this was the case with every single school in Ohio. But since much was written about this, in the newspapers of the day, some of it can be reconstructed. And a general practice was that the last period of the school day would be for religion, and then the kids would divide. That there would be a priest or brother or nuns, would come on campus for that last period and teach the Catholic children, religion, catechism, whereas ministers would come on and teach their children. That would be the last period of the day, and then everybody would go home. So that was a situation prior to the Bible War. The Bible War was triggered by the regulation, and the regulation ending this practice came to the attention of the Cincinnati School Board that some Catholics, were using religion class to promote views which were in opposition to the federalizing aspirations of the Republicans, meaning they were teaching states' rights, a states' rights interpretation of the Constitution, while Protestant ministers were using their religion class to promote the view that Catholic Democrats favored the Confederacy because it was a medieval-style agrarian economy which kept the majority of the population ignorant, meaning illiterate. When they said ignorant in the 19th century, they meant illiterate, that they would not be taught to read and write, and therefore docile through physical exhaustion because of the rigors of farm labor. Violence had already taken place in some schools over this, and the city government in Cincinnati was fearful of full-scale riots because Ohio had an active Ku Klux Klan. Sane moderates, caught in the middle, as sane people always are, feared that the pre-war bleeding Kansas could erupt in their state. They did not want a bleeding Ohio. And that's why the Cincinnati School Board used the separation of church arguments to tell both. So, okay, we're not picking sides between Catholic and Protestant, North and South, Democrat, Republican. Just, you're all out. So that practice of having the last period of the school day for religion, that's canceled. And no religious activity can take place. So we're not taking sides. It means, the Catholics cannot say the rosary. The Protestants cannot read the King James Bible. And nobody can even say the Lord's Prayer. No, you can't even sing hymns because we're not taking sides. They thought that was the best way, that completely 100% secular education was the best way to keep the peace. All right. So both Catholics and Protestants, even though they were at each other's throats otherwise, this united them because it affected both of them. And so they united temporarily to challenge this ruling in the courts. So it went through the courts for 3 years until the Ohio Supreme Court ruled in the case. The case was Minor, Minor, v. versus Board of Education of Cincinnati, 1872. It favored the Cincinnati School Board. And religion, from that point on, was quarantined from public schools in the entire state of Ohio. This is significant. It did not, the jurisdiction of that court did not extend beyond Ohio. But this is significant because other states encountering the same sort of internal conflicts looked to this decision and liked the outcome and believed that, in an insane world with all this conflict and all this emotion, that the quarantining of all religion from public schools was the best way to keep the peace and focus on the reading, writing, and arithmetic, education, as we'd say. Soon the rest of the nation would follow this. Eventually, state by state by state, would reach the same conclusion. The effect was to drain moral instruction of any kind out of public education for fear that it would be perceived as taking sides. So if you make for a public school teacher, somebody caught in the middle of this, a sane, moderate public school teacher, offering any instruction or answering any question from a child with moral content, well, if they, then they might end up getting accused of being pro-Catholic, which in this, in that context would mean, you're pro-slavery or pro-Klan. Whereas if you answered another way, well, okay, you might be considered Protestant, which means pro-federalist, and means that you're against your own state, like you're a traitor to your state because you want the federal government to run everything. So a teacher who just needs his or her job wouldn't say anything. They'd say, okay, that you talk to your priest. If a child would ask a question, okay, is this right or wrong? Okay, you're an Irish Catholic, you talk to your priest. Another child would ask something, and it would be an Anglo, say Lutheran. That you talk to your minister. Right? So that's how education, religious instruction became completely quarantined. So remember, seminarians, nothing just happens. Nothing just happens. Okay, the reasoning of the Ohio State Supreme Court regarding the use of the Bible in public schools is also instructive, because the school board's regulation that was at issue also stipulated that even the Bible could not be used. And that was something that all Christians agreed on. The only difference, as we saw in the 1840s, was the translation. So it could have been possible for the school board to say that no sectarian religious activity, such as the Catholic Rosary or Protestant hymn singing, could take place on campus. However, the Bible, we could have just a Bible class, and the Catholics could use the Douay-Rheims translation, and the Protestants could use the King James Bible. But that's not what the Cincinnati School Board stipulated, and it included removal. It included the Bible in what was quarantined, that also could not be used, any translation. So again, they're not taking sides. That's why they did it that way. We're not taking sides. And the Ohio Supreme Court's reasoning on this established a post-Civil War judicial thought that culminated in the officially atheist public school system of today. In the case, defenders of using the Bible in public schools justified the practice based on Article 1, Section 7 of the Ohio State Constitution. The relevant sentence reads, quote, "Religion, morality, and knowledge, being essential to good government, it shall be the duty of the General Assembly to pass suitable laws to protect every religious denomination in the peaceable enjoyment of its own mode of worship, and to encourage schools and the means of instruction." End quote. This phrasing was adapted from the Northwest Ordinance of 1787. That was, if you recall from earlier in the course, the federal statute which created the rules for admission of of new states from the territories, the Louisiana Territory, and subsequently other territories that we either conquered or purchased. So again, nothing just happens. We don't have, we have the territory, then it's a state. There's a process for that, legally, the first legal process that created that pipeline was this Northwest Ordinance in 1787, and the Ohio State Constitution, having been part of that Northwest Territory, this ordinance, when the state constitution was written, it adapted that writing, that thinking from the 18th century regarding that regarded religion as essential to moral instruction. Right. Now, those favoring the Bible in public schools argued, among other points, based on that wording, that the Ohio State Constitution, based on the Northwest Ordinance, allowed Bible reading, since it said the wording of the text of the Constitution was that religion was to be encouraged. It didn't say what religion, but religion. The Ohio Supreme Court disagreed and reversed the lower court, thus agreeing with the Cincinnati School Board. The Ohio court addressed this concept that the constitutions, the Constitution of the nation and the constituent constitutions of the states, meant Christian when the word religion was written. Is that the case? So the defenders of the use of the Bible was saying, okay, that quote that said religion was to be encouraged, were assuming that religion, ipso facto, that religion means Christian, that essentially there was no other religion than Christian. So the court, referring to Section 7, Article 1 of the state constitution, Justice, the one who wrote the opinion, was John Welch, W-E-L-C-H. He wrote the following, quote, "The real claim here is that by religion, in this clause of the Constitution, is meant Christian religion, and that by religious denomination, in the same clause, is meant Christian denomination. If this claim is well-founded, I do not see how we can consistently avoid giving a like meaning to the same words and their cognates: worship, religious society, sect, conscience, religious belief, throughout the entire section. To do so, it will readily be seen, would be to withdraw from every person not of Christian belief the guarantees therein vouchsafed, and to withdraw many of them from Christians themselves. In that sense, the clause of Section 7 in question would read as follows." And this is a quote of what hypothetically it would be. "Christianity, morality, and knowledge being essential to good government, it shall be the duty of the General Assembly to pass suitable laws to protect every Christian denomination in the peaceable enjoyment of its own mode of public worship, and to encourage schools and the means of instruction." So that, so that now back to his quote, his reasoning, quote, his opinion. "Nor can I see why, in order to be consistent, the concluding clause of Section 2, Article 6 should not read as follows: but no Christian or other sect or sects shall ever have any exclusive right to or control of any part of the school funds of the state. But Christians, as a body, including all their sects, may have control of the whole of said funds." Back to his opinion. "I do not say that such a reading of the sections in question is literally contended for, and yet I see no fair escape from it. If the word Christianity, or the words Christian religion, or religion of the Bible, are to be interpolated or substituted for the word religion at the place indicated." End quote. The court noted Those arguing for the reading of the King James Bible were arguing that the framers of the Constitution meant Protestant Christianity when they wrote the word religion into the founding documents. The Ohio court went on to offer this rebuttal. And again, I'm spending so much time on this because because nothing just happened. So this set a precedent. Even though the jurisdiction was only Ohio, other courts, judges, okay, what has this come up before? Okay, it did. What do the Ohio guys say about it? So that's just, that's why this is significant. Quote, if by this generic word religion was meant the Christian religion or Bible religion, why was it not plainly written so? Surely the subject was of importance enough to justify the pains, and surely it was of interest enough to exclude the supposition that it was written in haste or thoughtlessly slurred over. At the time of adopting our present Constitution, now he's referring to Ohio's, this word religion had a place in our old Constitution for half a century, which was surely ample time for studying its meaning and effects, in order to make the necessary correction or alteration, so as to render its true meaning definite and certain. The same word, religion, and in much the same connection, is found in the Constitution of the United States. The latter Constitution, at least, if not our own also, in a sense, speaks to mankind and speaks of the rights of man. Neither the words Christianity, Christian, nor Bible is to be found in either document. When they speak of religion, they must mean the religion of man, and not the religion of any class of men. When they speak of all men having certain rights, they cannot mean merely all Christian men. Some of the very men who helped to frame these constitutions were themselves not Christian. We are told that this word religion must mean Christian religion, because Christianity is a part of the common law of this country, lying behind and above its constitutions. Those who make this assertion can hardly be serious and intend the real import of their language. If Christianity is the law of the state, like every other law, it must have a sanction. Adequate penalties must be provided to enforce obedience to all its requirements and precepts. No one seriously contends for any such doctrine in this country, or, I might almost say, in this age of the world. The only foundation, rather the only excuse for the proposition that Christianity is part of the law of this country, is the fact that it is a Christian country, and that its constitutions and laws are made by a Christian people. End quote. Okay, so there's a lot in there that is very significant, because some of that reasoning you may recognize, from recent arguments about the application of generalized Christian morality to some social issues that have become legal issues. So what about all these assertions? The United States does have a Christian heritage. Of that there can be no doubt. At the time, even unbelievers had been schooled in the Bible and knew the general themes and stories. Like even an atheist knew about David and Goliath, or knew that about Moses went on Mount Sinai and got the Ten Commandments, or knew the parable of the prodigal son. Even if they didn't believe any of that actually happened, they at least knew the stories. Those who rejected miracles, those who rejected the Trinitarian God among our founding fathers, such as Jefferson, Adams, Franklin, were men who did believe that the moral teachings of Jesus were sound, the Ten Commandments, the Beatitudes. However, as the Ohio court stated or reasoned, the state cannot coerce conscience, Christian or otherwise, given the wording of the United States Constitution. The state adds nothing of spiritual significance to the church, while the church at least in our constitutional republic, has no need of the state approval to exist as a church. One of the lawyers, in this case, opposing the King James Bible in Cincinnati schools was a guy named Thomas Stanley Matthews. Matthews was a Presbyterian, practicing, a devout Christian. He was an elder in his church. He later became an associate justice of the U.S. Supreme Court. Yet he was opposing using King James Bible in the public schools. So that seems counterintuitive. His legal brief on the case reads like a theological treatise against giving the state power to enforce religious views on its citizens. So this has a long, so think way back to the beginning of the course, to the colonial period. So Presbyterian, that means Calvinist. That the Calvinist who came, the Calvinist colonists who came to the English colonies of the New World, the Pilgrims, the Puritans, the Presbyterians, those are all Calvinists. One of the reasons they left England was because the Anglican Church had established status in England. And meaning the king was head of the church, so it was a state religion, meaning that they had to pay taxes to support it, just like they pay taxes to support the government. But the Calvinists regarded the Anglican Church as papist because it retained some Catholic-sounding elements. They had bishops, they had priests, they had ceremonies that externally looked like the Mass. They wore vestments, they had hymns. And all those things Calvinists regarded as papist. So they did not want to pay taxes to support that. It's one of the reasons they came to the colonies. And so this guy, a Presbyterian, is a descendant of that tradition in which Calvinism was a minority, among the myriad of Protestant denominations, and feared that if a precedent were established of a generalized Christian religion being promoted in public schools, that it would not be the Calvinist version. It might be some other version of Protestantism. And so rather than risk that, this guy, even a devout, practicing Christian himself, agreed with the Cincinnati School Board that it is, rather than pick a side or risk the possibility that one side would gain ascendancy, it's better to remove the possibility from the equation. Just remove the Bible from public schools altogether and leave it to the churches. So Matthews revered the Bible, but believed that the Christian position must be to reject government, coercion of individual conscience. And the Ohio court agreed with him and provided its own lesson in theology. Judge Welsh argued that Christianity did not need state support, concluding with the following two sentences. Quote, "True Christianity asks no aid from the sword of civil authority. It began without the sword, and wherever it has taken the sword, it has perished by the sword. To depend on civil authority for its enforcement is to acknowledge weakness, which it can never afford to do. It is able to fight its own battles. Its weapons are moral and spiritual, not carnal." End quote. Okay, so this post-Civil War resumption of the Bible Wars set in motion a sequence of events that would lead to an attempt to outlaw Catholic schools in the state of Oregon. It would happen in other states, but Oregon is the one that was challenged and went to the Supreme Court. And that led to a Supreme Court case, Pierce versus the Society of Sisters, in 1925, which we'll get to eventually. So this is where, this is where it starts. Post-Civil War, as we'll see, post-Civil War, there were many things reset or reformulated, but in different terms, more secular terms, like the pre-Civil War social gospel will be reconfigured as secular progressivism. And in this case, the the pre-Civil War public school movement, which you remember was actually started by Protestants who wanted the King James Bible, just assumed that it must be part of instruction to teach basic morality. It's here after the Civil War, the public school movement is promoted again, but now it's going to be formed in a secular context. Okay, March 30th, 1870, the 15th Amendment to the United States Constitution recognized voting rights for African, or for blacks, as they said, but African Americans, as we'd say today. Now, that's not all of them. This is males only, over the age of 21. And it specifically included former slaves. Passed by Congress on February 26, 1869, ratified on February 3, 1870. The text, Section 1. The rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have the power to enforce this article by appropriate legislation. End quote. The 15th Amendment was the final of the 3 constitutional amendments enacted during the Reconstruction post-Civil War. Recall that in the previous decade, we covered the 13th Amendment, prohibited slavery. The 14th Amendment barred states from denying equal protection of the law. And now the 15th Amendment established that the right to vote could not be denied on the basis of race or previous condition of servitude. Though its express terms prohibit all racial discrimination in voting qualifications, the amendment was aimed at ensuring the enfranchisement of former slaves. Section 2 of the amendment, giving Congress the power to enact further legislation to enforce the right against any race-based attempts to deny the vote. The constitutional meaning of the Civil War was reflected in this amendment and the previous 2, 13, 14, 15. When the 15th passed, it represented, it wove into the organic law of the country a principle that African American citizens, and at the time most of them had been slaves, were entitled to political equality. Period. Neither the original U.S. Constitution, nor the Bill of Rights, nor any other provision of the Constitution expressly guarantees the right to vote. Such a text had been proposed at the time of the Constitutional Convention, which took place between May and September 1787 in Philadelphia. But it had to be dropped because such a guarantee, a universal guarantee of the right to vote. Now, this was, before the issue of, so it came up outside the parameters of the issue of slavery or race. And in 1787, it did. The guarantee of a right to vote was not in the Constitution because that would have derailed the entire project. Because each of the former 13 colonies had different voting rules. Most of the states, not all, but most, had property holding requirements. That, you had to vote, you had to have a stake in society, as they say. And if you did not have a stake in society, then you really had no right to vote. So that had a different philosophy of what voting meant. Like only those who contributed, so to speak, only those who had a stake, only those who were part owners of the society had a right to say anything. Anyone else, they would have regarded as, well, you're not contributing, so why should we listen to you? So most of the 13 former colonies that became the first 13 states did have a minimum property requirement to vote, but each state had different amounts of property. Some states actually permitted women to vote in the 18th century. And some states, like Pennsylvania, actually, even in the 18th century, allowed free black men to vote. But not all states did. I mean, so other states did not allow women to vote. Other states did not allow free black men to vote. So it would have derailed. So rather than try to put that in the original Constitution, it was left out. As a result, the only text in the original Constitution in which voting was directly recognized pertains to choosing members of the House of Representatives. Article 1, Section 2 provides that the people eligible to vote for members of the U.S. House would be determined by whom the state, the constituent states, let vote for their own House of Representatives. The 15th Amendment changed that, or rather constricted what the states could do, constricted the regulations the states could apply. Such that the 15th Amendment prohibited racial discrimination among any state passing any voting regulation. Later in history, the 19th Amendment, passed by Congress 1918, ratified 1920, prohibited discrimination on the basis of sex, so that it applied the 15th Amendment reasoning to women, or expanded the reasoning to include women. Even later in history, the 24th Amendment, passed by Congress 1962, ratified 1964, prohibited the use of poll taxes or property requirements in national elections. So even that late, the 1960s, there was still either property qualification or a version of it, meaning a tax that someone had to have enough substance to be able to pay to vote, so to show that they were that they were worthy of voting. So 1964, that ended. Even later, the 26th Amendment, passed by Congress in 1971, March 23, 1971, ratified the same year, July 1st, 1971, changed a portion of the 14th Amendment, which prohibited denying the vote to those over 18 years of age. So it changed the minimum voting from 21 to 18. Overlapping these developments in the mid-20th century, Supreme Court decisions added specificity to the voting regulation process. For example, the Supreme Court created the one person, one vote doctrine, which requires that there must be fairly equal numbers of people in election districts when electing representatives to a political body, meaning that all the congressional districts in a state must have, not exactly, to the numeral same number, but a similar number of people. Before decisions in the Baker versus Carr case, 1962, Reynolds versus Sims, 1964, and similar cases, there were some districts in a state which might have 1 million people, where another district in the same state might only have 100,000 people. But voters in each district would each only elect one representative to Congress. The Supreme Court concluded that the 14th Amendment reflected principles of political equality that required each district to have, to the extent possible, an equal number of residents, which is how the court defined the one vote, one person. The number of voting seats in the House of Representatives has been 435 since 1913. It was capped at that number by the Reapportionment Act of 1929, except for a temporary increase. 1959 to 62 was increased to 437 when Alaska and Hawaii were admitted as states in the Union. So how was all this decided? Well, not just calculated. The Huntington Hill method, that's, like last names of people, Huntington Hill, of equal proportions, has been used to distribute the seats among the states since the 1940 census reapportionment. Federal law now requires the clerk of the U.S. House of Representatives to notify each state government of the number of seats apportioned to the state no later than January 25th of the year immediately following each decennial census, as they say in the Constitution. We have to take a census every 10 years, so that's the decennial census. The size of a state's total congressional delegation, which in addition to the representatives includes 2 senators for each state, also determines the size of its representation in the U.S. Electoral College, which elects the president. So if a state has 9 representatives and 2 senators, then it has 11 electoral votes. Since 1789, when the federal government began operating under the Constitution, the number of citizens per congressional district has risen, of course, because the population has risen, so it's had to be, reformulated. In 1789, the average district had 33,000 people, residents. In 2018, the last time I looked this up, the average district had over 700,000. Prior to the 20th century, the number of representatives increased every decade as more states joined the Union and as population increased. So, for example, the millennial census, the year 2000, the number of representatives increased. So in the millennial census, 646,000. After the 2010 census, 709,000. And after the 2020 census, up to 761,169. It's the average in the district. Another area of the voting process in which the Supreme Court involved itself is specifying the right to physically access a ballot box and cast a vote. 1966, Harper versus the Virginia Board of Election. 1972, Dunn, with 2 N's, D-U-N-N, versus Bloomstein, and other cases. The court decided that restrictions on who could vote would be subject to strict scrutiny, which is the most demanding, the highest judicial standard. Once that standard was announced, the court quickly held unconstitutional virtually all restrictions on voting other than citizenship, residency in the jurisdiction, and age under 18. To evaluate other regulations of the voting process, the court in later decades, such as 1992, Burdick versus Takushi, created a test, a 2-part test, that first requires courts to decide if a burden on the right to vote is severe or not. And that severe is in quotes. That's the word, part of the standard. If it is, the regulation can survive only under strict scrutiny, which most regulations fail. But if the burden is not severe, the regulation is more likely to be upheld. Some more current constitutional controversies about regulations of the voting process take place under that Burdick framework and require courts to decide first whether a regulation imposes a severe burden on the right to vote or not. So, as we all know, the recent election, 2020, and there are all sorts of allegations, which that's take us too far afield. But so in all the court cases, there were at least 24 court cases. These are the standards. That's why I spent, these are the standards. It's that there's still the 15th Amendment issues, still going on. For the first 20 or 30 years after the 15th Amendment was adopted, black adult males were permitted to vote and did so in large numbers, such that during Reconstruction, nearly 2,000 African Americans were elected to public office during the period. However, starting in around 1890, for reasons that we'll cover, Southern states adopted an array of laws that made it extremely difficult for African Americans and also for many poor whites to vote. This was the start of the era of Jim Crow, the disenfranchisement, which lasted until 1965, the Voting Rights Act, 1965. Those laws required people, for example, to demonstrate literacy or prove their good character or pay certain voting taxes, poll tax, or overcome other hurdles before they were permitted to vote. As a result of those local laws, African American voting in the South was kept at extremely low levels between 1890 and 1965, despite the 15th Amendment. The situation only began to change dramatically in 1965 when Congress used its power to enforce the 15th Amendment by enacting the Voting Rights Act of 1965, the VRA. The VRA provided a number of means for the federal government and federal courts to ensure that the 15th Amendment was enforced, that the right to vote was not denied on the basis of race. And all of those issues are still very much with us. Access to the ballot box, well, for everyone, but also, those of different political beliefs and those of different ethnicity. So seminarians, remember, ethnic hatred. It's still with us. Always a profoundly effective tool of the demonic. Okay, let's see, where are we? Okay, we've been going for an hour, so we'll stop here, and then the next video we'll pick up with the First Vatican Council, also happened in this decade. For the moment, thank you for your attention. This session is adjourned.